Well, there's actually a couple options, and we're fairly fortunate in this area that the court has recently given us guidance in a case that involved Kmart and suitable seating in a class action context. Suitable seating is probably the next big wave of class action litigation I'm expecting the restaurant industry to have to deal with. Everyone's gotten used to the wage and hour cases, but this is likely the next area or wave we'll see. It'll likely be in your fast food context and your fast casual concepts where there's a person at a POS going ahead and taking orders and having to do things. What the ruling out of the Northern District said in the Kmart case was that employers could factor in people's perception of service with the employees. But they said we also need to take a look at the efficiency. The options for the employer is, in the end, we need to prove that the efficiency would go ahead and be disrupted by giving the person a stool, or there might be safety implications. But we have to do the work before we get sued on this. What needs to happen is the employer needs to go ahead and conduct that efficiency study that shows that a person, by going ahead and having to get up from a POS, go over to the drink fountain, get the drinks, coming back, is over the course of a day actually going to bog down the line, slow down service, and disrupt the customer flow in the restaurant. That's the type of evidence we want to see currently to go ahead and beat back this expected wave. It's something that we help people with. If you are faced with one of these, though, employers want to make sure that counsel they select is going to have class action experience, because they're not going to be one-off cases. They're going to be cases involving allegations that everyone within your organization is being denied suitable seating at the POS system or somewhere else. And there's ways to combat that. It's fairly narrow, but at this point, the best suggestion is the efficiency study that I've mentioned.